SJC-13294, Commonwealth v. Clifford M. Martin.
Okay, Attorney Stiles, good morning.
Good morning, Justices. My name is Attorney Ethan Stiles, and I'm here on behalf of Clifford Martin this morning. And we're here today because because Mr. Martin had a sentence appeal after his conviction, and the appellate division at first gave him one sentence, and then believing that it was an illegal sentence, gave him another. And we challenged that.
Wait, was it an illegal sentence or illegally imposed?
Well, the appellate division believed that the sentence it originally gave was an illegal sentence and that it was below the statutory minimum. Our argument here today is twofold. First, that the statute does permit this kind of sentence, and even if it didn't, the appellate division took too long to correct it. So let me start by looking at we must look at the statute, and the statute has two sentences that relate to the punishment for Mr. Martin's crime. And the first sentence is the one that everyone seems to focus on, but it cannot be read in isolation. It must be read with the second sentence. And that has been overlooked by more than one jurist and party in this proceeding. But it does say, except in the case of conviction for a first offense of this violation, the imposition or execution of the sentence shall not be suspended, and no probation or parole shall be granted until the minimum imprisonment herein provided shall be served. So in this case, you say, well, isn't the minimum sentence a 5-year term if the judge sentences him to imprisonment? And I suggest that it is not a minimum term as the court has defined it under Commonwealth versus Rossetti, because there is the second sentence here which permits a judge to lower the actual minimum amount of time he has to serve.
Can I ask you about the double jeopardy component? Assuming it's an illegal sentence, can I ask you about the double jeopardy component to it? Is a judge bound by Rule 29, or could the appellate division fix things on their own as opposed to a party?
Well, the appellate division certainly did proceed in a manner not unlike a Rule 29 sentence, where they imposed a sentence, later believed that there was an issue with the sentence, and then had a new hearing to take action to correct the sentence. And so they did function like Rule 29. And I'm not sure that the appellate courts have ever particularly determined whether Rule 29 applies to it or not.
Because we're talking about expectations in Solavka, right?
I'm
We're
sorry,
talking
Justice?
about expectations of finality on double jeopardy in Solavka, what we've said in that case. So,
Yeah.
and I'm just wondering where your client's double jeopardy claim intersects with the court's inherent authority to fix its own mistakes.
I would suggest, Justice Gaziano, that the 60-day limit applies either by Rule 29 or by this court's holding in the CPCS cases back during the beginning of the pandemic. It applies to Massachusetts. So essentially, a court has 60 days to take action on its sentence and no more. Because if the justices may recall, in the CPCS cases, there was an issue. Should we extend or allow beyond the 60-day period for Rule 29 cases so that persons who are in danger of COVID but didn't quite make the cut could file their sentences and perhaps get released? And the court said, no, we do not have the authority to do that. That will be cutting into either the judicial branch or the executive or the legislative branch to set.
So your position is it cuts both ways, for both to reduce a sentence and to increase a sentence? That limitation.
Well, to increase a sentence, definitely. To reduce a sentence, that would depend on what the issue of it was.
Well, obviously, there's no double jeopardy issue to reduce the sentence, but
no.
But I'm just wondering if we need to be consistent in that ruling.
I believe so. I believe that the court should be able to say that in this Commonwealth, if the sentencing authority doesn't catch it in 60 days, it's too late. And I would note something that I didn't put in my...
Even if it helps your client?
Oh, no, not if it helps the client. Oh, it hurts. But I would note something in my brief that I didn't put in my brief, is that a short time period for correcting or amending mistakes, 60 days, it may seem long, but it's not necessarily. For example, the federal cognate
Have any position as to whether or not it should be less than 60 days, given that the statute authorizing the appellate division to operate says that its decisions shall be final.
I did make an argument in my brief, Justice Wendlandt, that does speak to that, and that refers to the
But
city.
what do you say now?
Well, I say that 60 days would be an appropriate period of time, but there's also, if you wish to consider it, there's the argument about the sitting, namely that the appellate court, it meets once a year, it has a sitting, it meets in a particular period of months to hear all the cases from the counties that have arisen since it last met, it hears them, it decides them, and then it moves on. Now that's sort of an old-time relic of the way courts used to operate, and older cases have held that once it's no longer within its present sitting, it has no authority to act. So that is an alternative, although I would suggest, the concept of reasonable time is simply too
I'm sorry, when you say that is an alternative, you mean a year?
No, I meant, no, I meant you have your hearing, you have your new sentence, the court finishes its business, and then that would be another break on the process. It couldn't revisit it because it would no longer be its current sitting. It would be the next sitting would be too late under the older ways that the court used to consider sittings. So I've argued that, but if that seems to be a little too constrained, then the 60-day period at least has the.
I'm sorry, so just to put a fine point on it, you're speaking so quickly that I can't hear that fast. So you're saying that the appellate division could correct during the sitting?
Yes.
Okay.
Now, the sittings tend to be about 10 to 15 days, so the time period is fairly short, at least in my understanding of the practice, having been there a couple of times. Now, when I talk about that particular period of time, say 15 days or thereabouts, this is not a unique circumstance. For example, as I was about to say, that Federal Rule of Criminal Procedure 35A says that for correcting clear error within 14 days of sentencing, the court may correct a sentence that resulted from an arithmetical, technical, or other clear error. So it's not like Massachusetts is unique in this regard in having a short period of time to correct sentences if it may be disadvantageous to the defendant.
How do we weigh the double jeopardy issue compared to your case versus Salafka, where in one case the sentence was already served, and in this case this person was still, your client was still within the incarcerated period of the sentence? How do we weigh that? Well,
I think we look at it in a little different light, Justice Cassiano, because he had the sentencing by the trial judge. He filed his notice of appeal of sentence. He waited for a particular period of time, and then he had another sentencing by the appellate division. And after that, he got a lower sentence, and obviously he was pleased, as you might expect, and things were good. And then about 6 months later, he gets something else that says, "Oh, we got to resentence you. We made a mistake." So there, between the two sentences of the appellate division, there's the double jeopardy issue. He has to come back and ultimately impose the higher sentence.
But he's in jail the whole time.
Yes, that is correct. But he's received a sentence, and we suggest that either it's too long or the sentence was imposed, illegally imposed, which I believe the case law that this court has developed over the past 20 or 30 years suggests there is no substantive difference between a legal and legally imposed sentence. And we talk about illegal in the sense that it was above the statutory maximum, and illegally imposed is that there was inappropriate considerations in the sentence, but still it remains that there is some troubling issue with the imposition of the sentence.
Make a point that a ruling contrary to your position might chill defendants' interest in going to the appellate division to pursue a lower sentence, in the sense that, well, it's a unilateral decision, and if the result could be that a sentence could be changed in a way that it couldn't be changed if you didn't go to the appellate division, that might chill going to the appellate division. Do you want to elaborate on that?
Well, if I understand your question, Justice Lowry, obviously defendants know that there is an inherent risk to go to the appellate division.
Well, the sentence could be increased.
Yes, sentence would increase. But the risk they undertake is that once they get their hearing and they get their new sentence, that's it. The proceedings are over. They don't expect to have to come back 6 months later or a year later or whenever this nebulous reasonable time is have to fight it again.
I thought your point was if he hadn't gone, there wouldn't have been the issue.
That's correct. But in a sense,
You're aware that DOC corrects these things all the time? That DOC will every now and then say, hey, the legal counsel from DOC will say, this was wrong, you can't do this by statute, and sentences get corrected all the time as a result of that.
The mitmus from the trial court, governs what the sentence is going to be, and even if that mitmus is incorrect, then the DOC must follow it or must try to take some kind of alternate procedure. Now, this court has, in prior instances, has permitted sentences that are clearly illegal under the statute to be the sentence because of a failure to act in a reasonable within the 60-day period, for example. But in this particular case, I argue that the statute in this case, the sentence in this case, the appellate division sentence, the 4 to 6 years is a legal sentence, and that is because the second sentence permits the.
Let's say we don't agree with you on that point, but your position is there's a hard and fast 60-day time limit to correct an illegal sentence if we think it's illegal.
Either there should be the hard and fast 60 days, or there is the end of the term. And neither of those were met in this case. But let me. But when we look at the second sentence of this statute, we must understand that it does permit a wider range of sentencing than the first sentence suggests. Because first of all, this is a first offense, and second, it talks about probation or parole, and it permits probation. Would permit a sentence of straight probation. It would have, prior to 1993, permitted a sentence of a suspended sentence or a split sentence. But we don't have that anymore. But we still have.
It wouldn't allow a suspended or a split. You can't have those on state prison sentences.
Prior to after 1993,
after
yes.
truth in sentencing.
But this statute was written in 1974, so.
Yeah, I'm just saying there couldn't be a suspended or a split.
Not anymore. But we do have something that is less than the 5-year minimum, which is the ability to set a lower minimum term to permit parole eligibility before the 5-year period. And that is what the appellate division did in this case. And there's nothing wrong with that under this particular statute. And this statute is essentially equivalent to the statutes that the court considered in Commonwealth versus Lightfoot and Commonwealth versus Rodriguez. And even in Rossetti, the court said that those types of statutes, they stand on their own merits because they have distinct language that permits this kind of sentencing arrangement, whereas the statute was considering in Rossetti that did not. It was much more strict.
How is it much more strict again?
Well, in Rossetti, the statute, which was a failure to register subsequent, it was being considered, did have language that said, no probation, no parole until the minimum, no good time, or words to that effect until the minimum had been served.
And this one has all sorts of options other than a sentence.
That's correct.
But if there is a sentence, doesn't it still have to be correct?
Not less than 5.
And it is, and I believe that this sentence is a correct one.
It doesn't fit within those parameters of not less than and more than.
Well, not less than not more than does apply, but essentially, if you look at the actual interplay of the statute, the only not less than really applies for a second and subsequent offense, if so charged, because that's the way it reads. I mean, obviously, the court has to work with what it's given by the legislature, even if that language may not quite reflect contemporary values. It still may consider if it's permissible. And I would suggest that under this statute, any sentence from the 1 year minimum, 1 year, 10 year, as long as there's at least a 5 somewhere inside of that range, that is a permissible sentence.
So can you just tell me in your last 35 seconds, what moment did jeopardy terminate?
Jeopardy terminated with the November appellate division sentence. Once he had been sentenced by that court back in November and given his lower sentence, that's when his jeopardy became final.
Well, it terminates, in your position, after the 60 days runs and/or the sit-in of the appellate division.
Yes, that's,
Patches, but it terminates.
yes, attachment terminates. So that's when it starts, and 60 days at the max is that's when it ended.
His finality expectation is after that 60 days, right?
That's correct.
Or the sitting?
Or the sit-in, which is a shorter period of time.
Okay.
If there are no further questions from the court, I would be happy to rest on my brief.
Thank you.
Thank you very much.
Okay, Attorney Campbell.
Good morning. May it please the court. Julianne Campbell on behalf of the Commonwealth. I'm here asking that this court affirm the single justice's denial of the defendant's 211-3 petition.
When does jeopardy terminate?
Certainly. And Your Honor, if I could first just acknowledge the victim's family, I do believe was trying to be present today. And if I'm not sure if they've made it yet, but if not, I'm sure they're watching online. With respect to when jeopardy terminates, respectfully, that is a fact-intensive question for each case. And I would point this court's attention to Commonwealth v. Ellsworth, most recently in 2020, and Commonwealth v. Solavka. And in both those cases—
Well, in Solavka, we said that there's a rule, right, that even an illegal sentence will become final after 60 days, no ifs, ands, or buts. It's not a fact-dependent inquiry, is it?
It is, Your Honor.
Where
and-
does Solavka say that?
Sure. So what Solavka says, and the issue in Solavka, is the long-delayed correction of the illegal sentence. What Ellsworth—
Solavka, the defendant was notified 7 months after he started serving the sentence. And here, the defendant was notified 6 months after the correction by the appellate division. Why is 60 days good enough for the defendant in Solavka, but not here?
Sure. So I disagree that it's a 60-day timeline. I recognize what Solavka says, but if I could respond to the factors that are outlined in Ellsworth in assessing—
But Ellsworth was before the 60 days, right? So I think let's deal with Solavka's statement that after 60 days, the interest in finality has quote-unquote crystallized.
Sure. So what Solavka says is that it's within the Rule 29 time period. And my position is relying on Callahan, which is cited in my brief, although I'm not sure I gave the correct citation. I have it if the court needs it. It's 419 Mass 306. But the specific language is that the time expired by the Rule 29 period. And in that case, this court cautioned the Commonwealth that the Commonwealth should move within the 60 days. The Commonwealth's position is, relying on Callahan, Rule 29 explicitly does not apply to the appellate division. And the appellate division instead, I would suggest, has the inherent authority to correct an illegal sentence. And specifically—
Even though the statute says the appellate division's resentencing shall be final. There's no revise and revoke from the
That's
appellate
correct,
division.
but this court has heard appeals from the denial, from an appellate division sentence.
But don't they go through the single justice?
That's correct, via a 211-3 petition, as was done here. And specifically, if I could just return to Callahan, the language that I'm relying on is, furthermore, had the motion been timely, the judge would not have had the authority to revise the sentence imposed by the appellate division. The order of the appellate division is final. Any appeal from the sentence is analogous to an appeal from any judgment or order, in that once a party enters appeal, the judge issuing the order from which an appeal is taken is divested of jurisdiction. Rule 29, I would suggest, simply by this court's rulings does not apply, and so the Rule 29 timeline should not limit the correction of an
Let me
illegal
ask,
sentence.
suppose the appellate division 3 years later said, oops, we made a mistake, we looked at our records, and we think that the sentence was illegal and it should be 5 years. Can they do,
No, and it's not my position that the appellate division
right,
can do that.
so I guess it's Justice Wengland's question, so then when does it crystallize? If Rule 29 doesn't apply to appellate division or judges, only parties, when is the magic date?
And that is why my response is that it is fact-intensive, because what this court has outlined in Ellsworth is that the factors that are to be considered are whether the sentence was illegal, here it was, whether the sentence was fully served, here it was not, the timeliness of a motion to revoke, one was not filed, this was sua sponte by the court's recognition of its own error, and whether a motion to stay the execution of the sentence had been filed, and obviously none was filed here as the defendant had already began serving his sentence. And it's my position that under the double jeopardy considerations outlined by this court, that here, where the correction was made, I acknowledge it's 6 months, but bearing in mind how the appellate division meets, it was at the immediate next sitting.
How do we assess timeliness in this instance? So I assume your position wouldn't be, if someone was serving a 20-year sentence, and on year 9, and they think they're going to get out of jail, and on year 19, a judge says, oops, I made a mistake, or some successor judge, and they said, you got another 3 years left.
That would certainly not be timely.
Okay, so then how are we supposed to write a rule that says what this is supposed to say?
Sure.
Other than Rule 29 strictures?
Sure. So what I would say is first that I'm not asking this court to adopt a bright line rule, though I know this court I think that would be helpful to most practitioners. I'll say that. I'm not asking for that.
Well, it's easy for practitioners because you got Rule 29. This is for judges and courts.
But had the Commonwealth been aware of the error then, I would suggest could not file a motion to revoke, because the Commonwealth's authority to do so is via Rule 29, which does not apply to the appellate division.
I appreciate that Rule 29 doesn't apply, but we're dealing with expectation.
Certainly.
And so if it's not 60 days, 60 days still is out there. It's palpable. It's implicit in the expectation. How do we address that?
So what I would suggest is, I think, frankly, this case probably poses the limits of what would be appropriate. Here, he was sentenced to, say, the 4 to 6 year sentence. He had not even completed 25% of that sentence, and it was corrected at the very next sitting. It would be a different position, certainly, if the defendant had a 6-month sentence, was nearing the end, and then the appellate division corrected it. I think double jeopardy would apply. But in this context, given that he was sentenced to an illegal sentence, which he has no expectation of finality in, and given that it was corrected 6 months into what was a 4 to 6 year sentence, I'd suggest that this does not offend principles of double jeopardy in this case.
So if you don't appeal to the appellate division, you get 60 days, and then your interest in finality crystallizes under Salvanka. But if you go to the appellate division and win, it's longer, and it depends on the facts, the totality of the circumstances.
I disagree. I think if you
I
have
thought that was your position.
No, my position is an illegal sentence is what's suggested.
Well,
I don't assume that the appellate division will sentence
yeah, let's change
illegally.
the hypothetical that after an illegal sentence is imposed and 60 days have passed under Salvanka, you have an interest in finality. But if you've appealed to the appellate division and also get the illegal sentence, your interest in finality is a function of the totality of the circumstances. That's the Commonwealth's position.
I think so. As the case law has been decided thus far, yes, that is my position.
You could get a higher sentence. You've put your
Yes.
sentence in play when you go to the appellate
Correct.
division. You could get a higher sentence
That's
at
correct.
the appellate division.
That's correct. Unless the court has further questions on the Rule 30 issue that my brother briefed, or the sentence itself, I'm happy to rely on my brief.
Can I just ask what the reasoning is behind saying it depends on how much of the sentence you've served?
Sure. So again, I'm turning to the factors of Ellsworth. I think where the considerations by this court have been outlined as to whether the sentence has been fully served and the timeliness of a motion to revoke. But in this case, I would suggest that the sua sponte decision of the court to correct the illegal sentence. I think it is in play because just to take the obvious hypothetical of 19 years in to a 20-year sentence, I can't deny that someone would have an expectation that they would be getting out in 20 years.
Yeah, but wouldn't that person have the same expectation at the beginning of their sentence, anticipating that they would be out at, when they were told they'd be out, when they were sentenced?
That is certainly true. However, that's also true with the interplay of Rule 29, the 60-day limit in the trial court. And yet this court has extended it to the 60 days. Here, I'm asking this court to consider the timeliness in conjunction of the sentence as a whole, which is an appropriate factor, and with respect to that it's only 6 months into a longer sentence, I do think that that expectation of finality is reduced in that circumstance, given that he sought an appellate division sentence. At the time, it was an illegal sentence, and you have no expectation of finality in an illegal sentence. However, this court's language has put the 60-day time limit. That's not from the federal considerations of double jeopardy. And I acknowledge that Rule 29 60-day limit applies to the trial court. I'm just asking that in this case, where there has been no prior application of Rule 29 time limit to the appellate division, that this court find that it doesn't violate his principles of double jeopardy.
And again, this is just about what the single justice here in this court decides, right? The rule that you're proposing for us is the rule that...
Candidly, I'm not asking the court to adopt a bright line rule on
No,
the double jeopardy,
you're,
but yes.
you're wide ranging.
Yes.
Oh, look at this,
But I
look at
do
that.
think that should the court look to find one, I think this case sets appropriate parameters in that, like I said, it was the next sitting. It wasn't 3 years into his sentence that they caught this error. I'm sorry if Justice Cipher had a
Oh,
question.
yeah, I do have a question, and that is that, assuming we agree with you, what sentence, what's the last line of the opinion?
I'd suggest that the appellate, well, I'd ask this court to affirm the single justice's denial, but the sentence of 5 to 6 years is wholly appropriate when the appellate division corrected
All right.
the 4 to 6 year
And if we
sentence.
agree with your opposing counsel, what's the last line of the opinion?
I believe he's asking for the 4 to 6 year sentence, and so if you agree with him, I suspect
Then
that's what
we would be imposing an illegal sentence.
it does seem that way.